Aloha nerds, I'm Jessica Nguyen, head of Contract Nerds. You're about to watch a recorded session from our Contract Nerds webinar series, where we break down real-world contract issues with experienced practitioners from across the contracts community. This session was designed to be practical, not theoretical, so whether you're in-house, in legal ops, procurement, or just working closely with contracts, you should walk away with insights you can actually apply. You'll find the presentation slides and any bonus materials mentioned in this session linked in the description below. Let's get into it. Hello, hello. Hello. Good morning, good afternoon, and good evening, everybody from wherever you're logging in from. Welcome to this month's Contract Nerds webinar on indemnification and insurance, hosted by Contract Nerds and sponsored this month by Paragon Legal. Please share in the chat box where you're logging in from and your LinkedIn profile link if you'd like to make new connections with other nerds. For folks joining for the first time, Contract Nerds is a special community because folks join us from all over the world to share their knowledge, learn, connect, and nerd out about contracts. All right, let me introduce myself. I'm Jessica Nguyen. I'm the head of Contract Nerds and a seasoned commercial attorney for about 2 decades now. And a little bit about Contract Nerds for some first timers. Contract Nerds is a blog, a resource, and community dedicated to contracts. Contract Nerds provides practical, relevant, and expert driven content through our website, webinars, and our newsletter. We have over 25,000 engaged subscribers. And so if you're not subscribed yet to our newsletter, please subscribe. We'll put a link in the chat and you can receive weekly emails with amazing and free contracting tips and learn about our upcoming events. All right, now today's topic, indemnification and insurance clauses, expert tips on the intricate interplay. Woo, how exciting. And with us today, we have two amazing speakers, Noelle McCall and Venizelos. This is such an important topic for us contract nerds because indemnification is a clause that we negotiate over and over. But really, it's also the insurance clause that's really important because it's really putting your money where your indemnity mouth is. That doesn't really roll off the tongue, but we're going to go with it. All right. A little bit about our expert speakers today. First, we have Noelle McCall, who is the national practice leader for contract review at Howden, with more than 20 years experience working in the intersection of contracts, risk transfer, and insurance. She's an expert on how to draft insurance and indemnity language that aligns with your actual coverage. So she is the perfect guest for today. And then second, we have Jim, who is a senior counsel at Paragon Legal. He's a seasoned general counsel with deep global experience. He's led enterprise contract management initiatives, strengthened risk and compliance for organizations, and has also advanced legal technology to drive efficiency. And what I love about Jim, too, is he is a dedicated Clevelander. And so if anyone's from Cleveland here, please give Jim a shout out in the chats. All right. Next, we have a sponsor. I'm excited to get started, but first, a quick introduction of our sponsor today, who has made this event possible to you all for no charge. All right, here with us today is Tracy Scanlon, VP of Client Management and of Client Development and Legal Affairs of Paragon Legal. Hi, Tracy.
Hi, Jess. Good morning, and hello, fellow contract nerds.
Yes, we have about 2,000 registrants of contract nerds ready to dive in about insurance and indemnity. But before we get started, Tracy, tell us a bit about Paragon Legal and what you do.
Yeah, happy to. Thanks, Jess. So, Paragon Legal is an alternative legal services firm that provides experienced and skilled attorneys, contracts managers, and legal ops professionals to in-house legal teams on an interim basis. So, our folks can hit the ground running and work as part of your team for a period of time when you need extra support. Use cases include overflow work, contract surges at the end of the quarter, end of the year, parental and medical leaves, you have maybe no money for headcount, but there is work to be done, or you don't know if an FTE is needed right now. For example, you're launching a new product and don't know how long that's going to take. Or maybe you need an SME or help with a discrete project. You can get a Paragon attorney in there to help you, and there is no need for expensive outside counsel.
Great, because a lot of legal departments are dealing with flat headcount, but do have a lot of overflow needs. So this is perfect. And so, Tracy, tell us what makes Paragon different than other flexible legal talent providers?
So this is one of my favorite questions, Jess. Three things. First, for us, legal skills are table stakes. You can get a stack of resumes anywhere. Paragon matches on soft skills and really focuses on the fit. So our person is a great match with your work environment and works well alongside your stakeholders. Two, our corporate team, myself included, consists of attorneys. So we have been in your shoes. We know what you want and you need and have a lot of market intel to share. And third, this year is our 20th anniversary. We have spent 2 decades supporting in-house legal teams in this manner, so we have a lot of experience.
Well, happy anniversary. And thank you, Tracy, for being here. And if folks want to get in touch with you, how can they reach you?
Yeah, so please go to our website, www.paragonlegal.com, or you can connect with us on LinkedIn. We have a lot of great content, sometimes funny, sometimes serious, always relevant to the legal industry. So please connect with us, and I hope everyone enjoys the webinar.
Thanks, Tracy. Our agenda for today. Here are the items we're going to talk about today. We're really going to start with a little bit of background on insurance clauses, the risk ecosystem, go really deep on indemnity language, the nexus to liability. We'll also, because this is very popular with contract nerds, go through a Redline live lab and look at actual indemnity language from both a vendor and a customer point of view. And then last but not least, we will go over additional insurance coverage language and walk through some actual case studies to avoid coverage gaps. And hopefully we have about 10 minutes left for some actual live Q&A. All right, next. Jim, take it away on all things indemnification.
Well, I'm very excited to be speaking about such a, as Jessica suggested, sexy topic. I also want to just tell you that Paragon Legal is not only great for the clients, but it's also great for the lawyers and contracting people who work for them. I've been with them for about 18 months, so maybe almost 2 years, and it's been a great experience. So keep that in mind as well. So welcome. Today we're focusing on indemnification and insurance, two provisions contract nerds see every day, and two that often carry more risk than almost any other part of the contract. These clauses determine who owns the risk, who controls the defense, and whether the business is actually protected when a claim arises. Too often, indemnity is negotiated without asking whether the insurance will respond or where the gaps are. Today, Noelle and I will look at indemnification as part of a broader risk ecosystem. We'll cover common drafting and negotiation issues, how indemnity and insurance are supposed to work together, and where misalignment creates real exposure. The goal is to help you spot issues earlier, ask better questions, and structure these provisions to better protect your organization. So here we go. Next.
It looks like actually we are going to kick it off with a fun poll. All right, folks, how confident are you? Do you feel when you're negotiating your insurance requirements? I would, if I could vote, I'm probably on the not very confident side, which is pretty sad considering I have 2 decades of experience with commercial contracts. And actually, I'm not alone. There's about 36% of you not very confident, and 40 something percent at somewhat confident, and only about 8% very confident. Jim, does that surprise you?
It doesn't, because quite frankly, and I've been doing this as well for quite a number of years. That's one area that I am always a little uncomfortable with. And, most of us probably go to our risk group and say, hey, what do I do? but it's really going to be helpful for Noelle to teach us all about all the intricacies of insurance and how they relate to indemnification. I'm really looking forward to it. So no, it doesn't surprise me, because I would say that's why I came to this webinar.
That's what I would have voted as well. All right.
So we're talking now about the three pillars of indemnity. So when I read an indemnity clause, I ask whether it will work when a real claim arrives. Every effective indemnity answers three questions: who's protected, what risks are covered, and how the obligation is invoked and handled. The who can quietly expand exposure. It's not just the counterparty, but as all of you know, it's oftentimes affiliates, directors, officers, employees, agents, and even in certain cases, downstream customers. The what is the heart of the clause: IP claims, data incidents, bodily injury, regulatory matters, breach-based third-party claims, and related losses. The how is where many clauses fail. Procedure is not filler. Notice, control of defense, counsel, settlement consent, cooperation, and whether the duty to defend attaches on an allegation rather than final adjudication all matter early in a claim. I find parties often spend months on triggers and minutes on mechanics. Then they discover they never agreed on who steps in, who pays counsel, or who can settle. The bottom line is, if you can't explain the clause, the indemnity clause, from complaint through to resolution, you're probably not done with it. You need to go back and you need to beef it up. Next. So trigger language is where a few words can shift risk allocation dramatically. Arising out of or relating to, in connection with, and any act or omission are much broader than caused directly by, to the extent resulting from, or arising from a breach of this agreement. Those are different causation standards, and they matter when facts get messy. Real claims are rarely neat and tidy. A security lapse can trigger a customer demand, a regulatory inquiry, a class action, and remediation costs all at the same time. Broad language pulls more of that into the indemnity analysis, especially at the duty to defend stage, when allegations matter more than proven facts. So sophisticated drafters don't negotiate trigger language in isolation. They ask whether it aligns with insurance, the limitation of liability structure, and the real risks of the deal. A vendor that accepts very broad language without matching coverage may promise to defend exposures that no carrier is going to fund. A customer that accepts very narrow language may find the costliest claims fall into gray areas. So a practical tip for indemnities is to make the obligation apply to claims and allegations, not just financial, finally adjudicated liability. Otherwise, you may end up sort of winning the battle on the clause on paper, but you're still going to lose the defense when the costs mount. Next. So this slide's really about discipline. The best indemnities don't start with a precedent. And, we all use precedents, we all use templates, but you've got to be really careful, especially with indemnity clauses. And I think the same is probably true, and Noelle will tell us, on insurance clauses. You've got to start with the business model. What can go wrong? Who can prevent it? And which third-party risks should shift? That usually leads to focused triggers: IP infringement, privacy and security events, bodily injury or property damage, violation of law, and sometimes breach, where breach creates third-party exposure. So I've seen, and I'm sure many of you have seen, agreements that borrowed indemnification clauses from the wrong industry. Indemnities cover risks like vessel collisions, but the real risks under the deal are unauthorized content or mishandled customer data. And those clauses were completely missing. But you look at that precedent that somebody stole from some other contract, and the clause looks pretty comprehensive, but functionally, it's completely misaligned. Over-inclusive indemnities create noise, prolong negotiation, and often produce uninsured promises. Under-inclusive indemnities create false comfort. And the goal with indemnity is not having a bunch of words or the most words. It's a credible allocation of identifiable third-party risk. That also makes the limitation of liability discussion cleaner. I have a simple rule. If a risk does not plausibly arise from the goods, services, or performance model at issue, or if no one's thought through the insurability and proportionality, it probably doesn't belong in the indemnity clause. Next. So the negligence versus gross negligence debate sounds doctrinal. Sounds like it's from law school, right? But commercially, it asks whether indemnity is ever going to trigger for the failures that actually happen. Most breakdowns, most problems in deals are ordinary lapses, right? I mean, they're a missed patch, a flawed implementation, an incomplete handoff, or a failure to follow processes. Those are all negligence scenarios. Now, we talk about gross negligence and talk a lot about gross negligence and wanting gross negligence, but it's a much higher bar and often creates a satellite dispute. The parties stop fighting about the third party claim and start fighting about whether the conduct was merely careless or extreme. And that delay is very damaging when the indemnity needs an immediate defense. So a practical compromise is to separate external from internal risk. For third-party claims, negligence is often the right trigger because the point is to place outside-facing liability on the party best positioned to avoid it. For direct disputes, ordinary breach claims remain governed by the damages regime and the limitation of liability. So the key question is whether the parties are allocating real operating risk or drafting a standard that's so high that the clause becomes ceremonial. And in practice, indemnity tied only to gross negligence, when you get right down to it, often ends up not being the right choice because people expect different results. You throw in gross negligence, most of the time it's only lawyers who understand what that term means. But because when you have a client who sees gross negligence, well, they think it's negligence. And they're going to be really unhappy if you and they, when they were advised to accept gross negligence. Next. So should indemnity apply to breach of contract? It sounds really simple until you unpack it. A customer doesn't need an indemnity to sue for a direct breach. Ordinary contract remedies usually handle that, subject to the limitation of liability. The real issue is what happens when the vendor's breach is the reason a third party sues the customer. And that's not a corner case. A breach of confidentiality can lead to regulator scrutiny and consumer claims. A breach of security obligations can trigger class actions or downstream customer claims. A breach of an IP representation can become an infringement suit. So the most workable compromise is usually no indemnity for direct inter-party claims simply because one side breached the agreement, but indemnity for third-party claims to the extent they arise from a covered breach or the facts constituting that breach. That scenario preserves the limitation of liability framework while still covering outside-facing exposure. So the trap in indemnity, especially, is an unqualified exclusion for claims. Arising out of breach sounds great, sounds easy and clean, but it can swallow the very scenarios that the customer thought were protected. A well-drafted carve-out would read something like, the foregoing exclusion applies only to direct claims between the parties. This is the important part. Shall not limit vendors' indemnity obligations with respect to third-party claims arising from or related to vendor's breach of its, let's say, IP confidentiality, data security, or compliance obligations under the agreement. This way, the vendor's protected from unlimited direct damages dressed up as indemnity, while the customer retains protection for the third-party exposure that the indemnity was designed to cover in the first place. Next. So first-party versus third-party claims. I mean, this distinction is foundational. I think most of us certainly understand the difference between the two. A first-party claim is a dispute between the contracting parties and is usually handled through the contract's remedial framework, including the limitation of liability. A third-party claim is different. An outsider asserts a claim against one party because of conduct, goods, services, or rights associated with the other. That's the classic domain of indemnity. The drafting danger is language so broad that it pulls in the indemnity's own internal losses into indemnified claims, losses, or liabilities. Then indemnity really becomes, a backdoor damages clause that can override the economic deal reflected in the limitation of liability. I've seen parties cap direct damages, only to face the argument that nearly everything became indemnified and therefore uncapped because the clause covered any and all losses arising out of the performance. Indemnity is not a refund mechanism, and you have got to be cautious in thinking that it is. It allocates external risk. Some fact patterns clearly can straddle both categories, like data incidents. So the clause needs to clearly say what happens in each circumstance. Next. So if scope tells you whether a claim's covered, procedure tells you whether the protection is usable. The first question is whether there's a duty to defend, a duty to indemnify, or both. Reimbursement after judgment sounds like it may be okay when you're reviewing the contract, but it's cold comfort when the indemnity has to engage counsel and respond immediately. Notice is the next pressure point. Indemnitors want prompt notice. Indemnities need protection against technical forfeiture. So well-drafted clauses, indemnification clauses say late notice to the indemnitor reduces obligations only to the extent that they delay to the extent the delay materially prejudices the indemnitor. If the indemnitor controls the defense, the indemnity should still retain the right to participate with its own counsel where reputation, regulatory posture, privilege, or non-monetary relief is at stake. So, that's a clause I think most people are familiar with, but sometimes, for some reason, we don't think it's necessary sometimes to put it in, that it's more bootstrapping. Well, it's not. Settlement rights are also where experienced drafters spend time focusing on. The indemnitor should not be able to settle in a way that requires the indemnity to admit fault, accept an injunction, alter their operations, or take on ongoing obligations without consent. So my practical mantra is that the first 30 days of a claim often determine the next 30 months. If the clause is vague on defense timing, notice standards, participation rights, or settlement limits, arguably you've left the most expensive part of indemnity to pure improvisation. Next.
Uh, we have a poll coming up,
Oh,
folks. But before we jump into the poll, Noelle, as an insurance expert lens, I would love to hear your thoughts on how to really up level the procedural language here to make sure a customer is sufficiently covered. Because the reality is, yes, a vendor will have insurance coverage, but also the customer will have their own commercial liability and cyber insurance coverage. How does that interplay with one another? What kind of language should they seek in the procedural language here?
Yeah, so it's important to try to align the scope of indemnity with the scope of additional insured coverage
Mm,
because you want the insurance to help support the indemnity obligations. But most of my clients don't want to offer broader additional insured coverage than what they're being required to indemnify for. So that's one of the things that's kind of an aha moment when I give a presentation to lawyers. That's why you want to look at both clauses together, the indemnity and the additional insured.
that's interesting because I'm suggesting, obviously, that procedural requirements are pretty important. And I guess it does say top concern. My top concern, my top concern would probably be, yeah, covered claims are sufficiently scoped to risk. I mean, that makes the most sense.
yeah, yeah.
I would agree
Interesting.
with that because, from a risk management perspective, when I'm looking at a client's contract, I'm not looking at it so much from a legal perspective since I'm not a lawyer. I'm looking at it more from an insurance and risk related perspective. So, there I would agree that that top choice there, covered claims are sufficiently scoped to risk.
Interesting. Interesting.
Yeah, that's probably the biggest. I mean, that's it may not be completely clear, and that would be my fault, but that is probably the biggest takeaway from the indemnity section, anyways, that
Yeah.
they are
Absolutely.
sufficient. Yeah, yeah, yeah. Great. So, from the indemnities perspective, um, the argument for uncapped or specially capped indemnity isn't just we want more protection. It's that some third party risks bear little relationship to contract value. For instance, in software, cloud, data deals, an IP suit, privacy action, or a major confidentiality failure can create exposure far beyond the fees paid. Um, Customers also focus on control. They didn't design the tool that's being used. They didn't choose the subcontractors. They didn't build the security architecture or decide how the services would be delivered. The vendor is usually better positioned to avoid those risks and insure against them. That's why sophisticated customers often seek one of three structures: uncapped indemnity for a small set of high severity categories, a super cap tied to a multiple of fees, or category specific treatment such as uncapped IP infringement, but capped general third party claims. The logic is consistent. If a risk can exceed contract value overnight, a cap tied only to fees is going to fail most likely when that indemnity is most needed. So the indemnity's position is not that every indemnity must be must be unlimited. It is that the liability structure should reflect where severe third-party exposure originates and who's best placed to prevent and fund it. Next. So from the indemnitor's side, the concern's equally real. Unlimited indemnity can be existential, especially in lower value deals or where pricing assumes bounded risk. Insurance, and Noelle will tell you this for sure, insurance isn't infinite. Policies have exclusions, and large claims can exceed limits or fall outside of coverage. That's why experienced vendors argue for proportionality. They may limit indemnity to third-party claims, narrow causation language, exclude uninsurable categories, or make some indemnity subject to the limitation of liability or a separate cap. If the vendor wants a cap tied to available insurance or a rational multiple of fees, it helps to explain that in practical terms. And that may be reasonable. The goal is not to eliminate accountability, it's to keep risk survivable. A liability structure that can't be funded is either going to be rejected by the counterparty, quietly breached when a claim arrives, or priced back into the deal. And we know how clients love that increased pricing, right, to cover that risk. Next.
Hi, nerds. Jessica again. Quick pause before we continue. If this session is helpful, I encourage you to subscribe to the Contract Nerds YouTube channel and newsletter. We regularly share full webinar recordings, practical contract breakdowns, info about free upcoming events and CLEs on contracts, along with conversations featuring contract professionals from around the world. Subscribing helps you stay up to date, and it also helps us continue to provide free, high-quality contract education for the community. You can also find the slides and bonus materials for this session linked below. All right, let's jump back in.
So when you read vendor red lines on indemnity, separate posturing from legitimate risk design. The classic moves are familiar to all contract nerds. Narrow, or you got to narrow arising out of or relating to the extent caused by. Limit indemnity to third-party claims. Strike indemnity for breach. Replace negligence with gross negligence or willful misconduct. Add subject to the limitation of liability and tighten defense and settlement language. These edits usually reflect an effort to reconnect risk to insurance and deal economics. Customers, though, sometimes assume every narrowing edited is in bad faith. And I automatically default to that and get all honked off about it. And that's really kind of stupid, because the better question is, what risk is the vendor actually trying to avoid? If it's first party uncapped exposure masquerading as indemnity, the vendor may have a fair point. If it's avoiding responsibility for core IP or data risks uniquely within its control, that's a totally different conversation. A practical vendor playbook is to narrow broad triggers, confine indemnity to external claims, propose separate treatment for severe categories like IP, and align carve-outs with actual insurance and pricing assumptions. The best vendor red lines don't just say no. They offer a risk architecture that the counterparty can really understand. Because most lawyers, too, are oftentimes on both sides of the coin. So in those circumstances, you can convince a lawyer of the wisdom of your pushback. And you shouldn't be ashamed to do that. And you should always try to make sure that they understand how you feel about risk. Next. So from the customer side, indemnity red lines are usually about usability, not just breadth. Customers push for an express duty to defend because reimbursement after the fact doesn't solve the immediate problem of paying counsel and responding to a claim. They want trigger language broad enough to capture mixed fact allegations, and they resist language that collapses third-party claims into limitation of liability when indemnity is supposed to allocate outside-facing risk in a different manner. The customer's fear is practical. If something goes wrong, they don't want to fund the defense, absorb the operational disruption, and spend a year arguing whether the vendor's indemnity applied. That's why customers also focus on settlement consent, participation rights, and insurance support. That's really important. I think most of us are aware, and Noelle certainly is, in claims management, the party paying the lawyers usually shapes the strategy, timing, and leverage. That's why sophisticated customer red lines focus on who has control when the dispute is forming and the expensive decisions are being made in real time. Also, I think it's essential that customers are given the opportunity to provide counsel at their own cost because of the importance of all of this stuff. Next. So if I had to condense this into a few takeaways, they'd be these. First, define the who, what, and how with equal care. Parties spend too much time on covered scenarios and not enough on defense mechanics, notice standards, and settlement authority. Second, separate first-party economics from third-party risk transfer. If you blur that line, you're either gutting the limitation of liability structure or discovering the indemnity clause doesn't do what you thought it did. Third, align indemnity with insurance early. Indemnity without insurance can be a paper promise if the indemnitor lacks resources. Insurance without aligned indemnity can be a coverage mirage if the contract requires something the policy will not support. Alignment matters not just for limits, but also for trigger language, defense obligations, additional insured concepts, and insurability. For customers, the priorities are straightforward. Demand usable defense obligations, focus on the risk categories that can truly hurt the business, and verify that the insurance program supports the transfer you negotiated. For vendors, narrow, vague triggers, keep indemnity focused on third-party exposure, and don't accept obligations that your pricing controls and insurance can't realistically support. The bottom line is indemnity clauses aren't trophies for your aggressive drafting. And that's something, I don't know, as a young lawyer, I never appreciated. I was always, oh, I got this great indemnity and they're screwed and, all that kind of stuff. But they're really tools for allocating the right risks to the right party in a way that works under pressure. Indemnity allocates liability. Limitation of liability shapes the economics between the parties, and insurance makes the arrangement survivable. When those pieces align, the contract behaves the way lawyers intended, and that keeps clients happy. So speaking of keeping clients happy, I'm going to pass it over to somebody who always does, Noelle.
Thanks, Jim. You're a tough act to follow. Next slide. All right, let's talk about one of my favorite subjects, additional insured coverage. When it comes to coverages required under contracts, this is the number one coverage, if you had to pick one, that you should focus on. Why is that? Because additional insured coverage can help support and pay for indemnity obligations under contracts. So how does it do that? And why is it required? What is additional insured coverage? Let's start there. Additional insured coverage is when, let's say, I'm the named insured under a policy. I buy an insurance policy and I add you as an additional insured on my policy. That means you get coverage under my policy. You get coverage for defense and also damages. Why are these usually added? Why is this usually required? There are two reasons to add an additional insured to your coverage or your policy. The most often reason is because it's required in a written contract. It's extremely common to have an upstream party to a contract, like a project manager, require a general contractor in a contract to include them as an additional insured. The second reason why I might want to add you as an additional insured is if I have a good business relationship with you and I want to add you as an additional insured. So those are the two reasons, but most often it's because the contract requires it. So looking at the contract is very important. Additional insured coverage is a risk transfer mechanism. It shifts the financing of risk for things like third-party bodily injury and property damage claims to the party that's performing the work. Now, it doesn't shift the liability. So if I'm doing work for you and you're included as an additional insured and you get dragged into a lawsuit or something because of what I do, I'm not the additional insured coverage, it doesn't shift my liability as an additional insured to another party. It shifts the funding of the liability for it. So where indemnity assigns liability and negligence and risk, insurance helps fund it. So additional insured is one way to do that. The coverage typically provides defense. Now, keep in mind, the insurance carrier is going to choose and control defense here. You don't get to do that as an additional insured. It can also cover settlements and judgments on behalf of the additional insureds. Now, I have a question for you, and I want to see how many people might know this, so answer in the chat if you would, but I'll give you the answer in a minute. Additional insured coverage is one of two general liability coverages that can be used to help support and pay for indemnity obligations in contracts. Does anyone know what the other coverage is? Let's see. And I'll just wait just a few seconds and then I'll give you the answer.
I didn't know you were
Okay.
going to ask this, Noelle.
I saw somebody say that. Okay, so somebody had the right answer. It's contractual liability. And I could talk all day about that, but we're going to focus on additional insured for this presentation. All right, so next slide. So why should you review indemnity and additional insured clauses in a contract? Why review both of these? What I find most often happens is the lawyers are looking at all parts of a contract and a risk manager might be looking at the insurance. But often they're not looking at these two clauses together. And you should be doing that because you can, as I said a moment ago, you can use the additional insured coverage to help support the indemnity. The indemnity clause, as Jim was so wonderful at explaining, defines the legal allocation of risk between the parties to the contract. It establishes responsibility as a matter of contract law. The additional insured coverage shifts defense to an insurance carrier up front, so you get upfront defense costs covered, rather than having to litigate indemnity first. Additional insured coverage gives you a funding mechanism or another pocket to help pay for that allocated risk. And I don't know about you, but I'd rather use insurance to cover losses than pay it out of my own pocket. It also reduces collection risk because the most insurance carriers have, or at least they're perceived to have, deep pockets. So even if the named insured goes bankrupt or something, the insurance carrier is still there and available to pay claims. Basically, indemnity allocates the liability in a contract, while additional insured coverage helps fund and finance it. Now, here's a quick tip for you. AI coverage can help provide immediate defense, even when contractual indemnity is disputed. And it looks like we might have another poll.
Wow, that's an amazing pro tip, Noelle. I did not know about the immediate defense benefit there. But yes, our last and but not least poll of the day Do you know the difference between named insured, automatic insured, and additional insured? Wow, I'm actually pretty impressed. It looks like, well, I would have voted no, there's a difference. I'm in that bucket. But actually, over 40% of folks here said, yes, of course I do know that. So you have a pretty well educated, from an insurance standpoint, Noelle, audience here.
Wonderful. I love it.
Yeah.
Shall we go to the next slide? All right. For those of you that might be a little hazy on what the difference is between these different insureds, let me just lay it out in plain, simple English for you. So, a named insured is the person or organization to whom the policy is issued. They purchase the policy to protect their company or to protect themselves. The named insured typically gets the broadest coverage of all the insureds that are covered by the policy. Now, out of the named insureds, there's a special one. That's the first named insured. That's the party typically listed first on the declarations page of the policy that has certain rights and responsibilities under the policy, such as they are the ones who need to provide notice to the carrier of claims. They are required to pay the policy premiums, and they receive notice of cancellation from the insurance carrier. There may be multiple named insureds on a policy. There may be a long list of them, but the first named insured, again, has certain rights and duties. Now, the second classification of a type of insured under a policy is what they call an automatic insured. And just like the name says, these are some parties who automatically get status as an insured under the policy because of their relationship to the named insured. So a few examples here include the named insureds, directors, executive officers, employees, volunteer workers, and also real estate managers. So that's the second group. Now, the third group are additional insureds. And these are persons or organizations who are added as an insured to the policy, typically, like I mentioned a few minutes ago, due to a contract that requires it or a business relationship. These parties are typically added to the policy by way of an endorsement, an additional insured endorsement. And there are a gazillion of additional insured endorsements out there. For example, the standard additional insured forms are issued by ISO. And on a general liability policy, it can have up to 40 different types of ISO additional insured forms. So it's important to get the ones right that you're requiring and having on the policy. Now, here's a pro tip for you. Do not request to be added as an additional named insured. Named insureds are those parties for which the policy was initially written to cover. That's not an additional insured. So you're going to cause confusion if you go including that in the contract saying, hey, I want to be an additional named insured. You're not going to get that. You will be added as an additional insured. Next slide. So what are some of the pros and cons to being added as an additional insured to the additional insured party themselves? Well, some of the benefits include the following. You get the use of the other party's insurance to help pay your claims. This can help preserve your own policies, limits, and protect your loss ratio from going in the negative, which would not be good. It also gives you a backup option for funding, what we call in insurance terms the belt and suspenders approach, because let's say you're requiring another party to indemnify you, but they go bankrupt. They have no money, they can't pay. Well, you still have insurance, the insurance carrier that can pay. Especially in the event of maybe the indemnity clause was thrown out by the judge because it's unenforceable. Well, you still have the insurance that can help pay things. So it gives you another source of funding if the indemnitor doesn't have the capacity to pay. It can be broader than the indemnity scope that's allowed by law. So you might be able to get broader additional insured coverage on someone's policy than they are required by law to indemnify you for. I would say that's a mismatch of coverage. So if I'm giving you additional insured coverage, I'm going to want to push back on the broader indemnity and just have the additional insured coverage line up with the same level of indemnity that I'm agreeing to provide to you. So additional insured coverage provides immediate upfront defense for insured claims. Why? Because additional insureds are insureds under the policy. And as an insured, they have the direct right of access to that insurance carrier to file claims. This also helps avoid subrogation because most insurance carriers will not subrogate against their own insureds, and that includes additional insureds. So what are some of the drawbacks? This all sounds wonderful and rosy. Why don't we do this all the time? Well, insurance doesn't cover everything. So policy terms and exclusions apply. And I once had a story where an additional insured was talking to me and they said, "Oh, I don't need my own insurance, right? Because I'm an additional insured on your client's policy." And I was like, "No, you still need your own insurance. It's not going to cover everything." Also, additional insureds don't get to control defense. The insurer does. So that's a con. So if you want to use your own defense counsel, you want to pick and control defense, you might want to go a different route. Broad form additional coverage, additional insured coverage might not be available by law. So, for example, most states don't allow broad form additional insured coverage that can cover the sole negligence of an additional insured for construction contracts. So you want to make sure you check the rules in your state for the type of contract you're doing. Failure to require and verify that the other party has the additional insured coverage that you're looking for based on the form and the date could result in less coverage than you're expecting or no coverage at all. We'll get into that as we look at some case studies. Also, other claims that have been filed against the policy might have reduced or totally exhausted the policy limits, and you're not going to know that necessarily. Limitation of liability clauses can also cap available limits, so make sure you check that limitation of liability clause. Next slide. So what are some of the pros and cons to a named insured for adding another party as an additional insured? Well, there's not as many benefits here, but we'll go through them. All right, so adding someone as an additional insured or another party as an additional insured on your policy can help support the named insured's indemnity obligations to provide defense and damages coverage with their insurance. It's a method of contractual risk transfer where you transfer the funding of contractual risk to the insurance carrier to help avoid paying out of pocket for some of your indemnity obligations. Some of the cons include that additional insured coverage you're providing might be broader coverage than it might be requiring in the contract broader additional coverage, insured coverage than is available commercially in the marketplace. So one of the most often requested additional insured forms is CG 2010-1185, which was originally issued back in 1985 and is generally not available today, but people keep asking for it because it can cover the sole negligence. Some courts have deemed it could cover the sole negligence of additional insureds. By and large, that's not really available today for most insureds today. So asking for that coverage in the contract might result in you having no coverage because the insured can't get that. The additional insured coverage scope might be broader than the indemnity scope. Again, watch out for those mismatches between the two clauses. Additional insured claim payments that are paid out under your policy, well, those use your policy limits, so those can reduce or exhaust your policy limits. Limits are shared between all insureds. So the more additional insureds you keep adding on your policy, the greater of a chance claims for those will keep eating up your limits. So that's something to consider. Also, adding other parties as additional insureds can increase your own loss ratio on your insurance policy. And that means your carrier's paying way more out in losses than what they're taking in premiums. So this can lead over time to increased premiums you're going to have to pay, less insurance carriers willing to write your coverage reductions, and even non-renewal where you have to go find another carrier to try to cover your insurance. Next slide. All right. So when it comes to additional insured coverage, I like to picture a triangle, right? There are 3 levels to it, and I'll speed up a little bit because it looks like we're running out of time here. Generally speaking, there's 3 levels. So the top portion is limited. So if I'm the named insured, I'm going to cover you as an additional insured, but only for my fault or negligence. I'm not covering any of yours. Partial or intermediate means if I'm at least partly at fault or negligent, then I'll cover you for all of yours as well. And then broad is I'll cover you for mine, I'll cover you for yours, even if you're the only one at fault. I didn't do anything wrong. Next slide. All right, so how to identify additional insured coverage? You can watch for this wording in the contract. And so from a limited perspective, look for wording only to the extent caused by or resulting from or on a vicarious liability basis. You've got a copy of this as a handout, so I'm not going to go through everything. I'm just going to hit the highlights. Partial, look for the wording caused in whole or in part by, or the use of some of these endorsements that are listed here. There's some of the most common ones used. Broad, watch for arising out of language because courts have deemed that could possibly cover the sole negligence of the additional insured. And it can cover the other party, even if they're only partly negligent and you didn't cause or contribute to anything yourself. Next slide. All right, so here's some sample language for you so you can kind of see how it might play out. Normally, you're not going to see the limited language because most contracts are written by an upstream party imposing insurance on a downstream party. And as you can imagine, they're not going to want limited additional insured coverage. They're going to go for either partial or broad. So watch for that wording and also pay attention to the addition dates. ISO form addition dates, 1219 means December 2019. 1001 means October 2001. Generally speaking, the older the ISO form is, the broader the coverage was for additional insureds. Over time, the coverage has gotten more narrow. Next slide. So there are 3 factors to consider when determining if and how coverage might apply. The first one is, in most cases, what does the contract require? Does it require additional insured coverage? What types of forms is it asking for? What wording is it using? Is it specifying that it's required to cover both ongoing operations and completed operations? Usually you have to specify both for a construction contract. If you don't say what you want, you get the lowest common denominator, or you don't get to choose what you're getting. It's just whatever you get. The policy also comes into play. What does the policy cover? Not just for the general policy terms and conditions, you've got to get a copy of that additional insured endorsement and look at it. How is coverage being triggered? What are some of the limitations and conditions? What are some exclusions? So you need to get a copy of it and look at it. Also, what does the law allow? So most states, like I mentioned, they won't allow you to provide broad form additional insured coverage for sole negligence for construction contracts. Also, when you're looking at things from other countries' perspective, this presentation, we're mainly talking about US coverage here, but when you're contracting with foreign companies and they're agreeing to add you as an additional insured, let's say they're located in China. You got to watch the jurisdiction that their policy's written in, because their policy probably says that insurance carrier will only agree to cover claims that are brought in suits filed in China. And that makes it kind of hard to get additional insured coverage. So you need to watch the jurisdiction. Next slide. All right, 3 factors also can impact if and how coverage can apply. So starting in 2013, ISO came out with 3 new limitations on many of their forms. The first one says, as an additional insured, you get the lesser of available policy limits or the limits that are required in the contract. And so you need to be careful how you word your requirements in the contract so you can trigger full policy limits if you want that. Otherwise, you're just going to get the lesser of the two. For coverage, the coverage only applies to the extent required in the contract or agreement. So let's say it's a construction contract and you're only asking for ongoing operations additional insured, or you're not even saying, you might not get completed operations coverage. And then it also impacts, it also comes into play where it says the coverage only applies to the extent allowed by law. Now, you would think that's a no-brainer, but ISO felt they had to add that in 2013. Next slide. All right, so now we're going to take a look at a few quick case studies. The first one, the problem is there's no completed operations. So I kind of give you a heads up on what happened here, what went wrong with the title. So for this one, this was in New York back in 2024. And what happened was an owner had a construction contract with a general contractor, the GC. And they required the GC to name them as an additional insured. The GC's contract with the sub for CCTV installation required the sub to indemnify the GC, the project owner, and a bunch of other parties as additional insureds. The sub had the CG 2033-1219 additional insured form. This is an ISO form, which provides coverage only for liability caused by the named insured's work performed for the additional insureds. Now, this is trigger coverage wording. This performed for on that form, that's important. What happened? The sub's injured employee sued the sub, the GC, the owner, or the other subs, I should say, only the GC was covered as an additional insured. Well, what happened? There was a coverage gap. The AI coverage did not apply to the other parties, the owner and the other parties that were additional insureds, because the sub was not performing work for them. That's a problem. What's the solution? Well, thankfully, we have one now. The contract should have required additional insured for ongoing and completed operations. And the ISO forms you can use to solve this problem are CG 2037 and CG 2040. That can provide completed operations coverage for the additional insureds. The sample wording is listed here. So you want to make sure when you're requiring additional insured coverage for completed operations that you spell out ongoing operations and completed operations. And a best practice is use an ISO form for that coverage as well. Next slide. All right, the next one here, additional insured coverage is not triggered. So, I think I have my case studies mixed up here. That's a little unfortunate. The story I told you about a moment ago, looks like my slides are a bit mixed up, because the sub wasn't performing work for each of the additional insureds, only the GC was covered. So the solution to that is the CG 2038 form that ISO offers, which provides coverage for ongoing operations for any parties. It provides automatic additional insured coverage for any persons or organizations, provided the named insured has a contract with and is doing work for one party out of all those who requires additional insured coverage for itself, such as the GC, and any other parties. And then you want to use the ISO CG 2040, which does the same thing for completed operations coverage. Now, most people don't know this, but the CG 2010 for ongoing operations and the CG 2037 for products and completed operations, those require work to be done for each additional insured or the coverage is not triggered. And that's why ISO issued these new forms, because as long as there's one contract that you're contracting with And in that contract, it requires additional insured coverage for that party and any other parties that need to be added. That triggers the coverage. You only have to be doing work for one of those additional insureds, not all of them. So here's some sample language around that. Keep in mind those ISO forms, and most people don't know that, even people that do construction contracts all day long. So, but thankfully there's a solution now. These forms were just made available a few years ago, the 2038 and 2040. Next slide. All right, this is the last coverage case study. So in this case, additional insured coverage was not primary. What does that mean? We'll get to that. All right, this case is from 2025 between American National Property and Casualty Company and the Charter Oak Fire Insurance Company. So what happened with this? Well, here's the coverage issue. Hamilton Partners managed a commercial building in Illinois, and they hired condenser people, who was the contractor, to service some AC units on the roof and include them as an additional insured. In June of 2015, while working on the roof, the contractor's employee doing the work, or one of them, was injured when they fell through a skylight and injured themselves. So you can imagine that probably hurt pretty bad. The employee sued Hamilton and others in Illinois court. Now, the contract required additional insured coverage to cover Hamilton Partners and the additional insureds, but it didn't require it on a primary and non-contributory basis. So primary and non-contributory is the second most required coverage in contracts. And what this does is it says, if I'm an additional insured, I want your insurance to insure me on a primary basis, meaning your insurance pays first. And it's non-contributory to me because I don't have to use my own insurance. So that's a primary and non-contributory. So what happened? The contract required additional insured coverage, but primary and non-contributory, it didn't mention anything about that in the contract. So as a result, the primary and non-contributory coverage was not triggered because the contract did not specifically require it. So what happened was Hamilton Partners, as the additional insured, they had to use their own insurance to pay first, and then the additional insured coverage paid on an excess basis. So how can we avoid this problem from happening in the future? Here's the solution. Anytime you're requiring additional insured coverage of another party, make sure you're also requiring that that coverage apply on a primary and non-contributory basis, because that way the named insured's policies pay first, the additional insured's policies are excess and are not required to pay. The most common requested form for this under a general liability policy in the US is the ISO CG 2001. All versions. Now, this can provide primary non-contributory coverage on the GL policies. And here's some sample wording that you can use, or this is what it could look like. Additional insured coverage shall apply on a primary and non-contributory basis with respect to the additional insured's insurance, self-insurance, self-insured retentions, and deductibles, with coverage at least as broad as ISO coverage form CG 2001. Next slide.
Wow. We're going to jump to the CLE code, folks, as we are at 5 minutes before the end of the session, and we would love to answer some of the Q&A. Noelle, that was amazing, and I'm now doubting myself. I'm pretty sure 60% of contracts or more, I did not include the primary and non-contributory basis language in my insurance requirements. Oops, I'm so sorry, all past clients. All right, CLE code number 2, folks. Before I verbally say it out loud, I want to repeat CLE code number 1, which is CNMAR, and the second code, PAR 26. PAR 26 is the second code. And remember, folks, we're going to send you this recording of this webinar, the presentation deck, so you can enjoy and reuse all the sample wording and look over the edits, the red lines, an indemnification checklist. And also, thank you, Noelle. She provided a how to identify additional insured coverage level document. and so much more. And you're going to receive that via email tomorrow. Uh, be sure to join us too next month. We already have an amazing webinar planned for you all about smarter contract operations. If you have a few minutes, please stick around for some Q&A. Oh my goodness, so much love for insurance questions. Noelle, I'm going to let you kick off some of these answers. All right. For named insureds, does insurance cover the cost of defense? If so, from day one or only on the final resolution of the claim? And if so, can a named insured select their own counsel? Woo, a lot of
Great questions. So that's a two-parter.
All right.
Okay, so named insureds or any insureds under the policy get immediate upfront defense. But the named insured, when they're using their insurance for this, they do not get to choose and control defense. The insurance carrier does that. So, great question.
Does the insured have a menu of law firms to choose from that they can select?
Not as an additional insured, because the insurance carrier is going to choose the counsel.
I see.
Yeah.
All right.
Yeah, in a lot of situations where, depending on the significance of the lawsuit and so forth, yeah, I mean, the insurance company chooses the counsel and controls the strategy and everything. But, depending on how important from a reputational perspective or otherwise, oftentimes, well, I don't know if oftentimes, but certainly sometimes you do hire your own counsel, but certainly the insurance doesn't pay for it. But you want to, I mean, I guess, Noelle, there's nothing preventing, is there anything preventing from me hiring my own counsel and, being involved in the negotiations, especially when there's, if you put a clause where settlement discussions need prior approval from the additional insured?
Well, that depends on the claim, but and when I'm saying that insurers choose defense, I'm talking about general liability. So there are other types of policies, such as professional liability and things, where you can have a pre-selected, pre-approved panel of legal counsel. So it can depend on the type of policy, but for the purposes of today's presentation, talking about additional insured, and additional insured by and large doesn't apply to professional liability. So that's why I was saying insurers control and choose the defense. Now, named insureds might choose their own defense and choose to pay for it, but carriers aren't going to, cover that cost. They can choose not to use their insurance if they want to go that route.
Probably not. That's why you got
Probably
insured.
not.
All right. A great question from John. And a top of mind for a lot of folks here is about AI liability. Can you talk about issues insurers are seeing now and how to address potential liability arising from artificial intelligence products and agents and what more?
Ooh, yeah. So the jury's still out on that. I've heard rumblings that a lot of people are saying, hey, that should be covered under cyber. And then other people are saying, well, maybe we need a specific policy to cover AI generated content liability. From a general liability perspective, a lot of insurance carriers are starting to put on exclusions saying, we're not covering liability for the use of AI generated content. So jury's still out. I'm not sure which way it's going to go, but that's what I've heard.
Interesting. And one more question, and folks, there's so much indemnity insurance related questions in the Q&A chat. So folks, I encourage you to connect with Noelle offline if you have additional questions. All right, a question from Sarah. Does additional insured status allow the indemnity to make a claim directly against the policy, or does this dilute the indemnitor's policy for its own protection?
Yeah, so an indemnity can be an additional insured. And if they're filing a claim as an additional insured, then yes, they have direct access to the insurance carrier to file a claim directly with them.
Okay.
Now, the other coverage that can help cover indemnity is contractual liability. So that works a little different, and it's kind of a complex discussion, so we don't have enough time to talk about it on the Q&A. But under contractual liability, you could choose and control your own defense. And then if the court says the other party's on the hook to pay for your defense costs, they can indemnify you and pay you back for the cost of your defense. That's actually one of the pros of using contractual liability coverage instead of additional insured coverage, because you can choose and control your defense and then have the other party indemnify you for it.
Interesting. Well, that's a great answer and a great question, because when I think about the process language, I'm always, as an indemnity, I always have to notify in advance the indemnitor of my potential claim. So great clarity there. All right. We're at the end of this wonderful and such an educational webinar. I've learned a ton. Thank you, Noelle and Jim, for sharing your nerdiness with all of us. Thank you, attendees. Over 1,000 folks joined live at some point. We're still at over 500 participants to this moment because they want to learn so much about insurance and indemnification. I hope you enjoyed your time with us today, and I hope you join us next month for another CLE accredited webinar. Save the date, April 30th, where we'll be discussing smarter contract operations, the process first approach to doing more with less. And finally, thank you, Paragon Legal, for sponsoring today's webinar and allowing this to be free for all of you. Please subscribe to Contract Nerds newsletter and follow us on LinkedIn to stay up to date on expert contracting tips and learn of upcoming free events. Aloha, everybody, and stay nerdy.